Hello and welcome. My name is Alan, and we are back with more on the U.S. Constitution. As always, I'm reading from my American Constitutional Law book, and today we will be reading the last amendment from the Bill of Rights, Amendment 10. Oh, excuse me. But Amendment 10 reads as follows. The powers not delegated to the United States by the Constitution or prohibited it to the states are reserved to the states respectively or to the people. So the idea is what is not listed in the Constitution and its amendments is not prohibited from the nation, but is to be decided by the states unless, an amendment is made that says this is how it must follow. So again, remember that if I've already forgot the name of the document. Articles of Confederation. That more power is given to the states than the national government. But that brought along a lot of issues. But there's still this push that we don't want states just being squashed by a central federal government. So, yeah. So, yeah, that's kind of just what it says. The central government, the federal government, shall have the powers listed in the Constitution and its amendments. But anything else, as long as it is not prohibited by the federal government, then the states are open to it as a law to make. So yeah, that's essentially what the 10th Amendment reads. Since we're here, let's go ahead and hit Amendment 11, which happens 7 years after the Bill of Rights. Bill of Rights, all 10 of those amendments are in 1791, and Amendment 11, 1798. It reads as follows. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. So, the judicial power, which is the courts, shall not, with trials and courts and such, shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So, again, if I remember right from the judicial uh, court series I'd been working on, I think it prevents any court from taking suits against the United States except the Supreme Court. So, yes, let's see here. I'm looking this up. It deals with, okay, sovereign immunity. Let me open this up. This is from Cornell Law. Purpose and early interpretation. Though the 11th Amendment's jurisprudence can appear esoteric and abstruse, and the decisions under it inconsistent, the amendment remains a vital element of federal jurisdiction that goes to the very heart of the federal system and affects the allocation of power between the United States and the several states. Let's see. The limit on state accountability on federal courts embodied through the amendment might seem a discrete, straightforward adjustment of our federal structure precipitated by early case law, but discerning the implications of this embodiment continues to occasion heated dispute. Let's see if we can find a little more here. What else do we have? Okay, in accepting a suit against a state by a citizen of another state in 1793, the Supreme Court provoked such anger in Georgia and such anxiety in other states that the first meeting of Congress following the decision, the 11th Amendment was proposed by an overwhelming vote of both houses and ratified with what was for that day vehement speed. Chisholm, in Chisholm versus Georgia, had been brought under the part of jurisdictional provision of Article 3 that authorized cognizance of controversies between a state and citizens of another state. At the time of the ratification debates, opponents of the proposed Constitution had objected to the subjection of a state to suits in federal courts and had been met with conflicting responses. On one hand, an admission that the accusation was true and that it was entirely proper so to provide, and on the other hand, that the accusation was false and the clause applied only when a state was the party plaintiff. So matters stood when Congress, in enacting the Judiciary Act of 1789, without recorded controversy, gave the Supreme Court original jurisdiction of suits between states and citizens of other states. So yeah, let's see if there's anything else in here we need to add. Early decisions. Let's see. Okay, so that looks like a lot of what I wanted to just point out what the 11th Amendment held. So yeah, it's that the state still has its own rights, own immunity, its own sovereignness, but it is in the Supreme Court only that cases against a state by citizens of another state or by a whole other state itself must be held in the Supreme Court. Cases against a state by another country or citizen of another country must be held in the Supreme Court. So yeah, that is essentially what the 11th Amendment reads. Let me go ahead and look up Chisholm versus Georgia. And again, I'll put links to this in the description below the video. Chisholm versus Chisholm. Let's see. We'll go with oyez.org. So we have a document kind of defining Chisholm versus Georgia. But a quick look here. Facts of the case. In 1792, Alexander Chisholm attempted to sue the state of Georgia in the United States Supreme Court over payments due to him for goods that Robert Farquhar had supplied Georgia during the American Revolutionary War. The defendant, Georgia, refused to appear, claiming that as a sovereign state, it could not be sued without consenting to the suit. So again, that's kind of how Amendment 11 landed the way it did. The effects of it and everything. But yeah, again, I'll have all these links in the description below the video. But as always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I'll see you all in the next video. Until then, later.